Yep, it's Jay Lava, and we're back with another episode of Tether Talk. And this one's coming straight out of the Tether mouthpiece itself, the good old root. Oh, no, I'm sorry. This was the griot from Byron I Never Wanted to Be Black Allen. And it says the federal court ruling in Louisiana puts protesters' activist group in at risk. Look, I'm going to just get to it. They trying to pull out this dude. You know who this dude is? That's DeRay Mckesson. DeRay Bussy Boy Mckesson. They trying to put him up front again, so now they trying to give him some clout, like he did some. He ain't do nothing. But it goes on to say an unarmed Baton Rouge officer is seeking damages against the activist DeRay Mckesson on claims that McKesson's neglect organization of the 2016 protest, which resulted in an officer being injured by a suspect who remains identified. Well, wait a minute. I'm not taking up for Mr. McKesson at all. That's not what I'm doing. But that sentence don't make sense, dog. Why they gotta remain unidentified? Why don't you put it on out there and say it with your chest? But see, that's how white supremacy allows anonymity throughout their people to spew or do whatever they want to do. It says an anonymous Louisiana police officer lawsuit against a prominent Black Lives Matter activist has been furthered after a federal appeal court last week upheld that if a person sustains injuries to a demonstrator's actions during a protest, the victim may sue the organization of the protest for neglect. Mm. So they're trying to set a precedent that if anybody gets hurt, even if it's staged, because we know they do stages, even if somebody gets hurt during said protest, then they have the authority to sue the group, no matter if the group had involvement or not. Because you can't, I mean, just because somebody's at a function doesn't necessarily mean they support the group. Case in point, just like when everybody was out there protesting for George Floyd, you had a whole bunch of people out there that wasn't necessarily there for the protest, just trying to get out the house, trying to start mayhem, trying to disrupt. There's all type of stuff out there. But anyway, the goes on to say the unarmed Baton Rouge officer is seeking damages against the activist DeRay Mckesson. And it says the court on June 16th ruled that because McKesson's plan for the demonstration reportedly included the state crime of blocking off the public highways, violence against police was foreseeable per the report. That doesn't mean that. There has been plenty of times when highways have been blocked off and other things have occurred without any confrontation with the police. There's no way to foresee if a provocateur is going to set it off with the police or if the police don't act as the aggressor. But it continues. This is the Fifth Circuit's last action to further the case after it was initially struck down in 2017 by a federal district court, as previously reported by the griot. As previously reported, the case was revived by the Fifth Circuit Court in 2019, only to be voided in 2020 by the Supreme Court, who ruled that a 7-1 that it needed further review by the Louisiana Supreme Court due to the novel issue of the state law. According to the Reuters, Louisiana Supreme Court justices have since ruled that the organization may be responsible legally for how the protesters act under the law, tort law, opening the door for the Fifth Circuit latest ruling. The critics of the lawsuit have deemed it inconsistent with the basis and principles of free speech. Following the Supreme Court's void of the case in 2020, the American Civil Liberties Union National Legal Director David Cole stated, "The Supreme Court has long recognized that the peaceful protest cannot be held for the unintended, unlawful actions of others. If the law had allowed anyone to sue leaders of social justice movement and other violent actions of others, then there would have been no civil rights movement added, and the lower court's ruling is a threat to the First Amendment rights of millions in America." I'd also like to note, if that's the case, when Heather Heyer was killed at the Unite the Right rally when they was chanting "We will not replace us," and she was rolled down. That means all the organizations that was there should have been sued, right? All of them, because they had all of them. Don't tread on me, the whoopty wop wham, the three percenters, the whoopty schemes. They was all together. So that means they killed somebody actually there. Somebody actually died. We ain't talking about assault. We talking about murder. Ran over with the car into protesters. All that. Y'all remember that? So that means they should be being sued too, right? But that is not the case. Don't let them fool you though. This should not be giving you no clout for this guy. This guy has no clout. Just because they tossed this little name up there, he's not getting it stuck to by the man or anything like that. That is BS. He ain't moving nothing, shaking nothing, baking nothing, or quaking nothing. And with that being said, I need you to do four things. I need you to subscribe. I need you to like for the spike in the algorithm. I need you to comment your vomit. I need you to share if you dare. And you say where, I say there. Player over here. You know what I mean? And that concludes another episode of the Keep It P podcast. Nah, I'll just play with y'all. Love, peace, blessings, and aloha. I gotta go high for show high. You already know how because I'm out the Doha.